Namaskar. In this video, we will be looking at the topic whether magistrate can issue summons against person not named in FIR and in chargesheet. Recently, the Supreme Court has given the judgment on the same question, and the name of the case is Nahar Singh versus State of Uttar Pradesh. Let's see the brief facts of this case to understand the concept more. The brief fact of the case are that the name of appellant, that is Nahar Singh, was neither mentioned in FIR filed by the complainant nor was he arraigned as an accused in the chargesheet filed under section 173 of CrPC. His name had transpired from the statement made by the prosecutrix under section 164 of CrPC. Based on this statement of prosecutrix, the Chief Judicial Magistrate had passed an order on February 5th, 2015, directing Nahar Singh to be summoned for trial on February 21st, 2015. This particular order was challenged by Nahar Singh through a criminal revision petition, which came to be dismissed. As a result, the appellant approached the Allahabad High Court by filing a criminal miscellaneous writ petition. The High Court dismissed the petition and held that it was the duty of the magistrate to find out with respect to complexity of any person apart from those who were charge-sheeted by sifting the collaborative evidence on record. In case the magistrate came to conclusion that there was clinching evidence supporting the allegations made against persons who have not been charge-sheeted, it was his duty, that is magistrate's duty, to proceed against such persons as well by summoning them. So, argued by this judgment, the appellant preferred a special leave petition against the said judgment of High Court, which was delivered on May 14, 2015. Now, the question before Supreme Court was whether a magistrate has power to take cognizance of an offence on the basis of police report with respect to section 190 subsection 1 subclause B of CrPC and subsequently issue summons to a person who is not mentioned in FIR or who is not mentioned as an accused in a police report. While deciding the question of law and the appeal, the Supreme Court bench of Justice Vinit Sharan and Aniruddha Bose analyzed and relied on essential case laws, including Dharampal and others versus State of Haryana and another. In this case, the court was of the opinion that magistrate has the power to take cognizance and issue summons even if the name of person is not mentioned in FIR. The court further noted that the case of Dharampal had affirmed the view of the Supreme Court in an earlier judgment of Kishan Singh and others versus State of Bihar, which dealt with the same issue. The court had in that case opinion that it is the duty of the magistrate to investigate the matter while taking cognizance of an offence and go to the root of the offence by identifying the offender. Once he has done so, it is his further duty to take action against such person irrespective of person being mentioned in any police report. This was said by the Supreme Court in those cases. However, in this case mentioned just now, the accused person was either named or charge-sheeted in FIR. But in present case, the same both were absent. On this point, the Supreme Court observed that the principle reiterated in the cases where a person is neither named in FIR nor the charge-sheet, and said that the cases above are not confined to the circumstances of those cases, but are also applicable to the person were neither named in FIR nor in chargesheet. They bring out the duty of magistrate to find the offenders and proceed against such persons, as stated in Kishan Singh and Rugbans Dubey versus State of Bihar. Hence, the principle of law laid down cannot be said to be restricted to mentioning of a person in a charge sheet, police report or FIR, the court held. As a result, the Supreme Court upheld at the judgment of High Court. Now, what conclusion do we draw from this case? The conclusion we draw is Section 190 of CrPC empowers the magistrate to take cognizance of criminal cases. Taking cognizance implies the application of judicial mind to the facts and circumstances of a particular cases. A magistrate can take cognizance of a case on receipt of a complaint or a report by police or information received by a person other than police officer or upon his own knowledge. Therefore, the apex court reiterated the duty of magistrate to find the offenders who really are and punish them respective of whether they are not mentioned in FIR and charge sheet. In case of Nahar Singh versus State of Uttar Pradesh, which is the present case which I was discussing right now, the Supreme Court recently held that magistrate has the power under Section 190 of CrPC to issue summons against persons who have not been mentioned as an accused in the charge sheet or arraigned in First Information Report, FIR. Therefore, we conclude that yes, the magistrate has the power to issue summons against person not named in FIR and charge sheet. Thank you.